Hello everyone, I'm happy to be with you today, although I would have preferred to be standing in front of you in a few weeks for this presentation. However, the current conditions force us to use other means of communication, and so this is why I've decided to use an experimental feature of Zoom to perform this presentation. As you can see, Zoom now allows anyone to turn themselves into some kind of weather guide. So I'm going to be your weather guy for 15 minutes, except that instead of talking about the weather, I will talk, as you can see, about the importance of complying with the GDPR. And to do so, I will use a very concrete example which has made the news in the data protection world. And this case is the Google case, which happened in France. The CNIL, which is the Data Protection Authority in French, sanctioned Google to a hefty 15 million euro fine, and this sentence was upheld recently by the Supreme Administrative Court in France called the Conseil d'État. But before going into the details of this case, I would like first to take a few moments to answer this question. Why should you be concerned about respecting the GDPR if you're not located in Europe? Well, the straightforward answer is that the GDPR not only applies to organizations which are in Europe, it also applies to the processing of personal data of data subjects who are in the Union by a controller or processor not established in the Union, where the processing activities are related to the offering of goods or services, irrespective of whether you ask money for it, to such data subjects in the Union, or the monitoring of their behavior as far, of course, as this behavior takes place within the Union. So you must comply with the GDPR wherever you are, if you offer goods or services to people located in the EU, or if you monitor their behavior. Okay, so let's now turn to the Google case. What is it about? Well, in May 2018, two French associations lodged a complaint with the CNIL. And they alleged that Google had failed to respect on their internal platform the GDPR requirements concerning information and transparency and concerning the data subject's consent to data processing. And in January 2019, the CNIL found Google in violation of those requirements and sentenced them to this 50 million euro fine. This number is a lot higher than what was possible before in the data protection world, at least in Europe, because from now on, well, the GDPR states that an organization can be sentenced to a fine which is up to 4% of the total worldwide annual turnover of the preceding financial year, whichever is higher. So that makes it possible to give a 50 million euro sentence. Some still think that it was not enough, but it still is the biggest fine for data-related concerns, which has been given yet, at least in Europe. So Google made an appeal from this decision to the Conseil d'État, and the Conseil d'État upheld this decision in June 2020. So let's study now more precisely the two grounds on which this decision rests. First of all, information and transparency in the GDPR. And to tell you about this first ground, I will first tell you about what the GDPR says, and then we'll see how Google was found in violations of those requirements. Article 12, paragraph 1 of the GDPR states that the controller shall take appropriate measures to provide any information referred to in Articles 13 and other provisions, which I will not get into, relating to the processing of the data subject in a concise, transparent, intelligible, and easily accessible form using clear and plain language. But what is Article 13 about? Well, it deals with the information that must be given to a data subject in the event personal data are directly collected from him or her. And it sets forth pieces of information which must be given, such as the purposes of the processing for which the personal data are intended, as well as the legal basis for processing. And this information is very important because the purpose of processing not only commands various consequences under the GDPR, but it is also the main deciding point for data subjects on whether he or she will authorize the processing of his or her data. So, one more thing I wanted to tell you about, there is also the requirement to disclose the period for which the data will be stored and the criteria that will be used to make this determination here. So you would expect those requirements from any modern data protection regulation. However, what really sets the GDPR apart is that requirement over here. The controller shall take appropriate measures to provide any information referred to in Article 13 in a concise, transparent, intelligible, and easily accessible form using clear and plain language. And this requirement is a major milestone in data protection law, and it requires a major change from previously established practices in the industry. And Google's failure to take into account, at least seriously enough, this requirement caused their demise in this case. And let's see now why. I was not able to retrieve screenshots of the then applicable Google procedure to obtain consent and inform data subjects about the data processing activities of Google. However, when you read the CNIL and the Conseil d'État decisions, you can picture really well what it looks like, because we have all seen that kind of procedure, whether you've used Google services before or even with other companies. So to inform people, Google used a multi-layer approach with a first layer of information giving access to further layers of information if links and buttons were clicked. While this approach was not criticized in itself, the way it was implemented was, however, deemed inadequate when tested against the imperative of conciseness, transparency, intelligibility, and accessibility. First of all, if the GDPR requires conciseness, it nevertheless expects the information to be relevant and precise. And in that respect, the Conseil d'État judged that the first level of information offered to users appears excessively general in view of the scale of the processing operations carried out by the company, the degree of intrusion into privacy they involve, and the volume and nature of the data collected. The CNIL, for instance, insisted in its decision that the purposes of processing, which were stated in the documents, were not precise enough. More precisely, statements such as provide customized content and advertising services, ensure the security of product and services, provide and develop services. The information we collect is used to improve the services offered to all our users. All those statements were deemed inadequate. And I'm sure you can all appreciate how common and widespread those phrases are in privacy policies. Well, you should mind now that, well, those statements are considered in violation of the GDPR requirements concerning information. Google was also sanctioned because the implementation of the layers of information, which were supposed to bring additional information, was deemed inadequate. So the Conseil d'État judged that critical information relating to certain processing operations is only accessible following numerous actions or is only accessible via hypertext links, which are themselves difficult to access. And for instance, the Conseil d'État judged that the procedure to obtain relevant information relating to the personalized processing of advertisements was deemed inadequate. Here's what the Conseil d'État judged. In order to obtain all the relevant information relating to personalized processing of advertisements, a user must first carry out 3 actions from the first level of information before returning to the initial document and carrying out 2 new actions, i.e. a total of 5 actions, while 6 actions are necessary to obtain exhaustive information on geolocation. The information on the data retention period is only accessible through a hypertext link available on the 68th page of the confidentiality rule document. And I'm sure you have seen this kind of practices in many privacy policies or cookie choice boxes on the internet. Well, this is not tolerated under the GDPR. And the Conseil d'État concluded that the information structure chosen by Google appears, by the scattering of the information it organizes, to be detrimental to the accessibility and clarity of the information for users, while the processing operations in question are particularly intrusive in view of the number and nature of the data collected. So this was about Google's violation about the requirements of relating to information and transparency. Let's now turn to the consent requirements of the GDPR. I will once again tell you about what the GDPR says and then why it was judged that Google failed to respect those requirements. So what does the GDPR says about consent? Well, contrary to a popular belief, asking consent to a data subject is not always necessary to be able to process his or her data. Consent is only one of 6 grounds provided by Article 6 for data processing to be lawful. So you can perfectly, if another ground is applicable, process someone's data without his or her consent, although you will have to inform that person. But you don't have to ask for his or her consent. If you decide to use consent as your ground for processing data, then you must respect all the conditions which are set forth requiring asking someone's consent under the GDPR. And if you fail to respect those requirements, then you will be found in violations of the GDPR. What are those conditions? Well, first of all, you can derive some of them from the definition that's given of consent under the GDPR. And you can read here that Article 4, paragraph 11 states that consent of the data subject means any freely given, specific, informed, and unambiguous indication of the data subject's wishes by which he or she, by a statement or by a clear affirmative action, signifies agreement to the processing of personal data relating to him or her. And other conditions are more precisely set by Article 7, paragraph 2, which states, if the data subject consent is given in the context of a written declaration which also concerns other matters, the request for consent shall be presented in a manner which is clearly distinguishable from the other matters, in an intelligible and easily accessible form, using clear and plain language. Google was found in violation of those requirements, and let's see that now. We have already seen how one condition set forth by Article 4 was violated in Google's case. Consent was not deemed informed because the information was not provided in a way that was in form and in substance compatible with the GDPR requirements. But Google was also found in violation of the prescription that the consent collection be clearly distinguishable from other matters, as well as specific and unambiguous. First of all, with respect to the clearly distinguishable consent collection requirements, the CNIL, which summed up pretty well the problem in its decision, observed that if a user does not click when creating his account on the More Options button so as to configure his accounts, he is only left to check the I accept Google's terms and conditions and I accept that my information be used as described above and detailed in the privacy policy checkbox. Well, for the CNIL, it follows that the specific nature of the consent is not respected since the user by these actions accept in bulk all the processing of the personal data implemented by the company. This is in violation of the GDPR, as data subjects should always be able to give a different and specific consent for each intended purpose for which consent is sought. This requirement is really not well understood in practice. And here is an example which I stumbled on as I was preparing this presentation. You have it's in French, but I translated it in English above my head. It's about Snapchat. Snapchat uses your location for functions like filters, the search tool, the snap map, advertisement, and even more. Well, in my opinion, this is a very good example of a violation of the GDPR, because saying even more is just to state how much you're in violation, because you're supposed to state every purpose for which you ask consent, and as we're going to see, you're supposed to ask a different consent for every purpose. Okay. There was also a problem, that's where I'm getting at, with the specific and unambiguous requirements. And it was debated in the decision for a feature which is critical to Google's revenues, which is personalized ads. In Google's consent procedure, no information was provided concerning those ads on the first layer of information. So the first thing you would see, you would read nothing about those personalized ads. Before you click create accounts. Not only the user had to click a More Options button to see information about personalized ads, but even more importantly, the box allowing the personalization of ads was pre-checked. Well, this was, at least for Google, a huge problem, because pre-checking a consent box is a crystal clear violation of the GDPR, as it violates the freely given and unambiguous consent requirement. And the European Court of Justice confirmed this in a case called Planet 49, which I encourage you to read if you're interested in those matters, and more precisely in this case about website cookies, which must not be pre-checked even if the data is considered non-personal, except if the cookie can be deemed strictly necessary for the operation. Since my time is running out, time has come for me to sum up the key takeaways of this presentation. First of all, the GDPR applies to any organization in the world which offers goods or services or monitors the behavior of data subjects located in the EU. Second of all, violating the GDPR can be costly. In the case of an undertaking, up to 4% of the total worldwide annual turnover of the preceding financial year. Third of all, one must be extremely careful when drawing up a privacy policy and related documents. And what you must really be careful at is that information must be concise, transparent, intelligible, and easily accessible form using clear and plain language, and you may not try to make things appear like you give information, and actually it's unreadable. From the moment the judge will consider that for the average user it's not really understandable, you will be found in violation of the GDPR. So you must really be clear, concise, transparent. And finally, when using consent, always give a separate choice for each purpose of processing, and never, ever pre-check a box for having consent, except in that little exception of cookie boxes for cookies which are strictly necessary for the operation of the services you are providing. If you want to become more knowledgeable in the GDPR, I encourage you to come and see us at Paris-Panthéon and to subscribe to our certificate in data privacy laws and new technologies, which will open starting in 2021. I hope you have enjoyed this presentation, and I hope to meet you on our Paris-Panthéon campus someday. Goodbye, and thank you.